the next one. Here it is the current affairs, the bifurcation bugbear, and the dispute occurs between the Telangana and as well as Andhra. So this article is basically talking about constitution, sub-theme, provision and constitution. So this article basically talking about the center and state relation as well. So what are the work of state and the center? So in this article we will get to know what exactly it is. So men's question that is based on this is Article 244 of the Indian Constitution relates to administration of scheduled areas and tribal areas and lies the impact of non-implementation of the provision of the 5th schedule of the growth of wing extremism. Think about how can we solve this question. Okay, so now if we talk about the Indian Constitution page, so Article 1 says India, that is Bharat, shall be the union of states. Why it is the union of states? The states and territories thereof shall be specified in the first schedule. So see, in the terms of prelims, schedule and article must we keep aware. So the territory of India shall comprise. So what is the territory of India? Will comprise the territory of the state, the union territories specification in the first schedule, and such the other territories as may be acquired. In the later on, once we acquire, that is not to be also a territory of India. So India, that is Bharat, shall be a union of state. Why it is not to be a union of states? Because center have a legitimate, or we can say center have a power to, most of the power has tilting towards the center. So basically in this article we'll get to know what exactly it is. Okay, so basically in the we can say the Article 1 of the Constitution of India 1950 was debated on 15th and 17th November 1948. India was a union of a state and went on a defined Indian's territory. Most members were confused as to why India is described as a union of state instead of federation, which was more appropriate on an earlier date. The drafting committee chairman explained the union of state was used to ensure the clarify that state did not have the right to succeed from India. So this is very important in terms of, because in the prelims exam, if you talk in the regard of polity questions, you have to be you have to keep on mind that the terms which has been used it, because that is very important. Because as we can see, lots of questions as in the previous year has been asked that is based on the term. So what does it mean the word republic? What does it mean the word republic? What does it mean the word state? What does it mean the word duty? So such questions has been asked earlier in your exam. So make sure that why India is not a union of a state, because the reason that because ensure the clarify state did not have the right to succeed from India. So that is the reason why it is known to be a India as a union of states. So a member wanted to rename India to Bharat as the letter had more historical pedigree. Another member introduced that amending to use both India and Bharat in draft article. So India, that is Bharat, shall be a union of states, except for one member who found that phrasing inelegant. The amendment who won the support of the House. Assembly rejected all amendments to the draft article except those introduced by drafting committee chairman. It adopted the draft article on 18 September 1949. So basically the article is so the issue is, where is the issue occurs? So federalism and what are the challenges? So as we can see, the power centering center, the debate is going on because sharing power is common, self-rule is not common. So center as well as regional federation and challenges. So we have to understand first what is the federal issues, because the article is somehow is interlinked with the above article, but we'll get to know So, because in the terms of federalism, what exactly it is federalism? So, federalism is a system of government in which the power is divided between a central authority and various constituent unit of a country. So, power dividing we can known to be as a federalism. Usually, a federation has two levels of government. One is the government for the entire country, that is usually responsible for the few subjects of common national interest. The others are governments at the level of provinces or state that look after much of the day-to-day administering of their state. Both these levels of governments enjoy the power independent of the others. In this sense, federation are constrained with unitary government. Federation are constrained with the unitary government under the unitary system. Either there is only one level of government or the sub-units or unitary system, which means that like only a state, like in the terms of USA. So only the unitary system, which means one is powering to the another, one is empowering to the another one. So there is only one level of government, or the sub-units are subordinate to the central government. The central government can pass on orders to the provincial or the local government, but in the federal system, the central government cannot order to the state government. Make sure that in a federal system, that central government cannot order to the state government to do something. A state government has power of its own for which it is not answerable to the central government. Both these governments are separately answerable to the people. Because in which case judgment it has been passed? Because here the main question has been asked. The concept of cooperative federalism has been increasingly emphasized in recent years, highlight the drawbacks in the existing structure and extent of which cooperative federalism would answer the shortcomings. 2015 and 14 it has been asked. Prelims question that is based on, consider following statement: an amendment to the Constitution of India can be initiated by an introduction of a bill in the Lok Sabha only. If such an amendment seeks to make changes in the federal character of the Constitution, the amendment also requires to be ratified by the legislature of all states of India. So what it could be the right answer? As we can see, So first one is the amendment of the Constitution of India can be initiated by the introduction of a bill in the Lok Sabha only. So amendment requires the bill from the Lok Sabha and Rajya Sabha, right? If such an amendment seeks to make changes in the federal character of the Constitution, the amendment also requires to ratify the legislature of the all states, not that the particular states, not the all states of India. So the right answer is D1, which is this one. Neither 1 nor 2. Both the statement were incorrect. So as we can see, it like an amendment to the Constitution of India can be initiated by an introduction of a bill in either house of the Parliament. If such an amendment seeks to make changes in the federal character of the Constitution, the amendment also required to be ratified by the legislature at least half of the states, not the all states. So make sure that amendments requires that can be initiated by either house of Parliament, either can be the lower house and upper house, which is the Rajya Sabha and the Lok Sabha. And we can say the next one, we can say the amendment also requires to be ratified by the legislature of at least half of the states, not the entire states of India. So, which one of the following is not a feature of Indian federalism? These are 2017 question. They're asking about the feature of the Indian federalism. There is an independent judiciary in India. Powers have been clarified divided between the centers, between center and the state. The federating units have been given unequal representation in Rajya Sabha. It is the result of an agreement among the federal unit. So how can we say which is not a feature? So try to, this word is important. You must keep an eye on that. It has been asked not a feature of Indian federalism. So in that case, so there is an independent judiciary in India. So think about that. What could be the answer? Okay. So what is not a feature of Indian constitutional federalism? First one, if you look it very carefully, there is an independent judiciary in India. Yes, it is true. This is a feature of Indian constitution, Indian federalism, powers shall have been clearly divided between the center and the state. That's why we are a federal structure of in our country. So yes, B is the feature of Indian federalism. A is also the feature of Indian federalism. Third one, the federating units have been given unequal representation in the Rajya Sabha. No, this is an equal representation. There is an equal representation, unequal representation in the Rajya Sabha. Exactly, because different states have different representation. Maximum representation from which state? Maximum representation from the Uttar Pradesh. Around 30 MPs from the Rajya Sabha MPs. So this is the right one, not the equal representation of the Rajya Sabha. So C is also the, we can say, feature of the Indian federalism. Third one is the result of an agreement among the federating units. No, this is not the result of a federating unit, as this is happening in the USA, not in India. So as we can see, the D is the right answer, because it is not the result of agreement among the federating units. So previous year question, having a glimpse to that how the question has been framed in the near examination. So that you can think about that how you need to prepare short notes for the prelims and as well as mains exam is concerned. Okay. Now further moving, as we can see, sorry for the technical glitch. Okay, some key features of federalism we must keep in mind. There are 2 or more levels of tiers of governments. So different tiers of government governs the same citizens, but each tier has the own jurisdictions. So make sure that there are 2 levels of government is here. The jurisdiction of the respective levels of tiers of government are specified in the constitutions. So the existence and authority of each tier of government is constitutionally guaranteed. The fundamental provision of the constitution cannot be unilaterally changed by one level of government. Such changes require the consent of both the level of government, which is the central government and as well as state government as well. Courts have the power to interpret the constitution and the powers of different level of government. The highest court is as umpired if disputes arise between different level of government in the exercise of their respective powers. So basically we can say the highest court, that is the apex court, and which is the Supreme Court of India. If any dispute occurs, any disputes occur, and we can say any disputes arises between the different level of governments, so the Supreme Court will hand it over this. Okay. So next is that sources of revenue for each level of government are clearly specified to ensure its financial autonomy. The federal system thus has dual objectives to safeguard and promote unity of the country. What is the federal system? Federal system has dual objective to safeguard and to promote unity of the country. Same time, the accommodate regional diversity. Therefore, 2 aspects are crucial: the institution and practice of federalism. Governments at different levels should agree to some rules of power sharing. They should also trust that each would abide by its part of the agreement. An ideal federalism system has both aspects: mutual trust and agreement to live together. So this is also keep in mind. Okay, and then there are 2 kinds of routes which federation have been formed. The first route involves independent states coming together on their own to form a bigger unit, so that pooling sovereignty. So this word is keywords is pooling sovereignty. Pooling is similar, like in a general and lucid way we can understand carpooling means what? That people is helping to you. Similarly we can say that independent states coming together on own form of bigger unit, so that the pooling sovereignty and retaining identity, they can increase their security. This type of coming together federalism include the USA, Switzerland and Australia. In this first category of federation, all the constituent states usually have equal power and stores vis-a-vis the federal government, as the USA, Switzerland and Australia is following. Second is where the last country decided to divide its power between its constituent states and national governments. India, Spain and Belgium are example of this kind of holding together. So make sure here is pooling sovereignty, what the USA is following, and then we can say holding together. It means somehow the center is, some power of center is more than states, and center is tilting towards it, because as we can see, the farm law, education, like most of things are comes under the state list, but government, the central government can make a law for this. So the holding together federations, in this second category, the central government tends to more powerful states. Very often different constituent units of the federation have unequal powers of units granted special powers. So we can see it here, as I have elaborated in the way. As we can see, the in federalism and its challenges. What are the challenges of this federalism? So as we can see it here, the centralization of the amendments. As we can see, the Punchi Commission report. So what are the Punchi Commission report has been earlier? What the order says? So if you are aware about the lots of question has been asked earlier about this commission, and what the report says. So basically, Sarkaria Commission, Rajmanar Committee, and Punchi Commission. Punchi Commission giving a fixed term of 5 years to the governors, and the removal by the process of impeachment. Unions should be extremely restrained in asserting parliamentary supremacy in matters assigned to the state. It prescribes certain conditions that one should keep in mind while appointing a governor. He should be eminent in some walk of life. He should be a person from outside the state. He should be a detached figure and not connected with the local politics. He should not be given a fixed tenure of 5 years. So such kind of reports, Sarkaria Commission and Punchi Commission has been given. So as we can see, the emergency provision in Indian Constitution, like National Emergency Article 352, President Rule Article 356, and Financial Emergencies Article 360. So basically we can say the federalism challenges is here, like centralization of the amendments, emergency provision like Article 352, 56 and 360. SR Bommai case. So what is the SR Bommai case? What is exactly the SR Bommai case? So SR Bommai versus Union of India case, that is 1994, the Supreme Court had laid down guidelines regarding the use of Article 356. You cannot impose the national emergency. The President proclamation is important. Dissolving a state legislative assembly is subjected to judicial review also. Earlier it was not comes under the judicial review. If President rule is imposed only by political consideration, the court can even restore the assembly. A state assembly can be dissolved only after the parliament approves the president rules. So such kind of SR Bommai judgment has been important in terms of federalism. Like office of governor is that here appointment, reservation of bills, appointment of chief minister. So such things you just need to keep on mind. So because there are 3 lists: central list, state list, and concurrent list. Central list, like center can make a law, state list with state can make a law, and concurrent list with both state and center can make a law. But make sure that there is some residual list, residual powers. So which is if the anything, because at the time of independence there was no kind of such kind of cryptocurrency is there. So which government will make the power to make a law on that? So only this the central government, not have a state government have an authority to make a power on the residue and as well as concurrent list, right?